All right, hello and welcome, future barristers. If you are staring down the barrel of the Queensland bar exam, you know just how critical the UCPR is. Today, we're going to do a really focused deep dive on one of the most important and, frankly, most tested areas, the rules on expert evidence. Let's get right into it and get you ready.
So, you might be wondering, why do we even need this whole complicated set of rules? Well, it really all comes down to one single nagging problem, the hired gun. You know, the expert who is seen as just a partisan advocate, loyal only to the side that was cutting the check? The UCPR rules we're about to walk through were designed specifically to take that idea apart and put the expert back in their proper role.
Here is our game plan for today. We're going to start with the purpose of the rules, that's Rule 423. Then we'll look at who these rules actually apply to in Rule 424. After that, we'll hit some key definitions in Rule 425, and we'll wrap it all up with the absolute cornerstone of this whole area, the expert's overriding duty.
Okay, first up, let's talk about Rule 423. Honestly, if you can get your head around the why behind this entire framework, everything else is going to fall into place so much more easily. I want you to think of Rule 42.3 as the mission statement for this whole section of the UCPR. It literally tells you what the objectives are. And knowing that, well, that gives you the context for all the other rules we're about to discuss. So, what is that mission? Well, Rule 423 sets out four really clear purposes. First, to provide for court directions. Second, to declare the expert's fundamental duty. Third, to set up the rules for giving evidence through written reports. And fourth, to create a framework for appointing experts, either jointly by the parties or directly by the court. That's your foundation, right there in Rule 423.
And here is a really critical point, especially for your exam. Rule 423 changed, and it changed pretty significantly in 2022. The old rule, the pre-2022 version, was really focused on using a single expert. The thing is, that was a practice that just wasn't used very much. So the 2022 amendment shifted the focus to a much more practical framework of directions, reports, and joint appointments. Knowing that distinction is absolutely key.
Okay, so we know the why. Now let's get into the who. Rule 424 is where we define exactly who these expert evidence rules apply to and, maybe just as importantly, who they don't apply to.
Now listen up. Under Rule 424, there are four key exemptions you absolutely have to know. These rules do not apply to a party in the case, a person whose actual conduct is the issue at hand, a treating doctor, but only when they're giving evidence on their own treatment, and finally, minor claims in a magistrate's court. You've got to memorize these Rule 424 exemptions. They are prime exam material.
All right, next up, the language of the rules. Rule 425 is basically our official dictionary for this part of the UCPR. It defines the key terms, and we're going to focus on the two most important ones right now. First, what even is an expert? Well, according to Rule 425, it's a person who is qualified to give opinion evidence as an expert witness on an issue in the case. Now, the commentary makes it really clear that this definition isn't anything new or revolutionary. It's simply reflecting the long-standing common law position.
And that common law position? It's probably best summarized by the famous Makita test. An expert can't just get in the box and state their opinion and walk away. Their evidence has to show their work. It has to explain how their specialized knowledge applies to the facts of the case to produce their final conclusion. This, right here, this is the bridge between just having expertise and actually giving admissible expert evidence. It's a fundamental principle.
The second key term from Rule 425 is report, and the definition is about as simple as it gets. It's the document that contains the expert's opinion. But don't let that simplicity fool you. Remember what we said about Rule 423? Delivering evidence through these reports is a cornerstone of this entire system. Okay, now we get to it. This is the most important principle in this entire framework. This is the rule that looks that whole hired gun problem right in the eye and confronts it head-on. We're talking about the expert's overriding duty.
It all comes down to this one single line in Rule 429F. The expert has a duty to assist the court. Not the client, not the person paying the invoice. The court. This duty overrides absolutely everything else. It is paramount.
And Rule 429F doesn't stop there. It breaks it down for us. The duty is to assist the court. The expert is explicitly not an advocate for a party, and this duty to the court, it overrides any other obligation they might have, including to the party who hired them or is paying their fees. And finally, they have to comply with the code of conduct. This right here is the very heart of the modern approach to expert evidence.
So, this leaves you with the single most important question you need to ask, whether you're sitting in an exam or you're actually prepping a case for trial. You need to look at the evidence and ask yourself, is this expert actually assisting the court, or are they just assisting my client? Because under the UCPR, only one of those is acceptable. Okay, that's it for now. Good luck with your studies.